so we'll go ahead. It's 12 o'clock. We'll go ahead and get started. Welcome to Alcoholism. Hello? Oh,
Hello?
yep. Okay. So welcome to Alcoholism in the Bar, Ethical Considerations for Lawyers. This course has been approved for 1 hour general MCLE credit and 1 hour of professional responsibility in the area of substance abuse and mental health. I ask that you mute your audio, again, everyone except for the panelists, and reserve questions for the end. I'm Michelle Flagg, Director of Industry Education for the Illinois Liquor Control Commission. The Illinois Liquor Control Commission is committed to protect the health, safety, and welfare of the people of Illinois through careful control and regulation of the manufacture, distribution, and sale of alcoholic liquors, and through the development of strategies to reduce youth access to alcohol products and responsible beverage service. This month, April, is Alcohol Awareness Month, and alcoholism rates among practicing attorneys run twice the national average. Such problems can lead to disciplinary action, including license suspension and revocation. This Lunch and Learn will examine the nature of the problem, address the applicable sections of the Code of Professional Responsibility, identify consequences of an ethical breach, as well as available resources through lawyers' assistance programs. The scope of this audience for today will focus on attorneys, but is open to other professionals. And you'll also learn just tools. Other professionals can learn tools that can apply to their profession as well. So today, to discuss these matters on a local level, I have Tracy Kepler with CNA Lawyers Professional Responsibility Program, Dr. Diana Uchiyama with the Lawyers Assistance Program, and Melissa Smart with the Illinois ARDC. So I'll start the presentation. And we'll start it off with Tracy. Now, Tracy is a member of a task force that will that helps to address the well-being of attorneys throughout the country.
Great.
So
thanks
now
so
we'll
much, Michelle. Oh,
okay.
Thanks so much, Michelle, and thanks for everybody being on the line. I'm so disappointed that I didn't get to be there on the video. I thought I had figured out all the IT glitches. And I actually took a shower and got out of my pajamas today, so you would have gotten to see the real me. I guess my role in this presentation is really to sort of set the stage, to talk about the kind of data that we had, the kind of data that we needed, and where we've gone from here, both sort of nationally as well as locally. And then I'm going to turn it over to my colleagues, Melissa and Diana, to talk about the issue more. But as I said, let's go ahead and set the stage. Anecdotally, data from LAP, data from the ARDC told us that there was a problem with substance use, problematic alcohol use, as well as certain mental health concerns. But we really didn't have any studies or information to quantify the problem. And so back in 2016, 2 national studies were undertaken, one for law students that you can see up there. It was called Suffering in Silence, authored by Jerry Organ, who's at University of St. Thomas, David Jaffe, who is the Dean of Students at American University, and Kate Bender, who works for the Dave Nee Foundation. Another study was solely for lawyers, and that was done by Patrick Krill, I'm blanking on the first name, but also Linda Albert, who was the former director of LAP in Wisconsin. And they will, if you want to read more or you want more details, you can see where those articles were published in the Journal of Legal Education and the Journal of Addiction Medicine. And I'll go to the next slide. Looking at the law student survey first, particularly with regard to alcohol usage. What we found was, it was 15 law schools across the country. They had responses from 3,300 students. And in response to some of the questions that were asked about their drinking, how often they drank, how often they drank 2 or more drinks at a sitting, you can see the data. You can see the data for other grad students, and you can see the data for law students. And other than the binge drinking at least twice at the bottom, the rates for law students were significantly higher. You can go to the next slide. The survey also asked questions about mental health concerns, and you can see some of the percentages there where students indicated that they were having issues with depression, with severe anxiety, which I think those numbers are probably higher, mild or moderate anxiety, as well as suicidal thoughts within the past year. Next slide. The survey for law students also asked a few questions as to if you are suffering from these things or you're having a problem with your alcohol intake, why aren't you looking for treatment? Why aren't you talking about it? Why aren't you going somewhere? And so some of the factors that we found that were discouraging help-seeking behavior were the students were afraid that it would be a threat to their job or to getting past character and fitness with bar admission or to their academic status in school. They were worried about the social stigma of even talking about these problems. And also in some respects, they felt that, you know what, I can really handle this myself. I don't need help from anybody. I'm totally self-sufficient. I'm not gonna look out and seek any treatments. Next slide. So you can see this slide, we're moving into the lawyer study. And in the lawyer study, it was 15,000 lawyers across the country, whittled down to about 13,000. All geographic reasons, geographic locations, age, ethnic origin, practice setting, and the data really, turned us on our ears. We always thought that it was people who were more seasoned, people who had been out practicing longer, who were suffering from problematic alcohol use at greater percentages than younger attorneys. And what we found out was, and for some reason, I don't know what happened to the percentages on this. It's about 6% problematic drinking for the general U.S. population. For all attorneys, it goes up to about 24, 28%. But for attorneys under 30 years old, that rate was 32%, which really shocked us because, as I said, we thought it was the other way around, more seasoned attorneys suffering at greater rates. So attorneys under 30 and attorneys out of practice or out of law school for 10 years had the biggest issues. Next slide. Some other questions that were asked in this survey, which are particularly relevant for our discussion today, were some self-reporting concerns. And I think the one that has the largest number is sort of the most scary, where almost 50% of people who responded to this survey said that their problematic use started within the first 15 years following law school. 22% or almost 23 felt that their use of alcohol or substance was a problem sometime in their lives. Next slide. In this slide, you can see, you can see some of the rates of usage for alcohol. Obviously, alcohol being the most, and this was before marijuana was legal in so many states. But this is the preferred substance that lawyers typically go to. It's legal, whereas we see lower rates for ones that are, either illegal or using prescriptions without an actual prescription. But typically, alcohol is the most common, I'll say, self-medication substance that we see and that we saw in this survey. Next slide.
Status.
The study also asked about certain mental health concerns, and you can see some of the percentages from the responses. Similar to what we saw in the law school study, 28% felt that they had some symptoms or were suffering from depression. Again, 19% with severe anxiety. I think that is significantly higher, especially right now. Lawyers had a higher percentage of suicidal thoughts during their career, moving from 6% as law students to 11.5%. males, higher levels of depression than females, and we saw the same inverse relationship. The rates and the percentages were higher for attorneys who were 30 and younger. Next slide. Similarly to the law students, we found two main barriers to seeking out help in these issues. And, you know, they were the same. The first one being the stigma. I don't want anybody to know. Nobody can know about this. And the other, concerns about privacy or confidentiality, getting out to the firm, getting out to my colleagues, getting out to my partners, getting out to my friends. No one can know that I'm suffering and that I'm having these issues. Next slide. Some other concerns that were raised or that were indicated in the study, in addition to confidentiality and stigma, were concerns about my licensure. I didn't have insurance to get treatment. I didn't have enough money to get treatment or take time off from work. And sadly, I don't know who to ask. Luckily, I think we are really rectifying that with the education and outreach from both the ARDC as well as the Illinois lab. Next slide. The other thing that we looked at in the National Task Force on Lawyer Wellbeing is there something about lawyers? I mean, are we different as a profession? Are the times different? Why are these rates so high? And why are we seeing this you know, younger than 30 suffering at such great rates and such great incidences? And you can see some of the reasons up there on the screen. You know, I'll just highlight some of the ones that I see in my practice. Sort of this having to be on 24/7, always being connected to your device, whether it be your phone or your email, having to respond in a second's notice, even if it's 2 a.m. Things like, you know, lawyers are great at looking for risk, at looking for holes, sort of pessimistic and skeptical by nature, which is great for being a lawyer, but it's terrible when it comes to being a human being and in your personal relationships. Sort of the zero-sum game, you know, win at all costs, the perfectionism, imposter syndrome, where, you know, good is, you know, we have to be perfect at all times. Certainly, I think lawyers have a higher reserve, and in some ways they are able to hide or mask some of these problems longer. What we see, I think, from a malpractice place is that lawyers can hide it, you know, everything in their life will go. Their family, their friends, their volunteer, their house, but the last thing to go is their career and their job. The other thing is, you know, the billing structure, what our definitions of success, all of these things contribute to these incidences. And so what we thought was I'll say 6 of us getting together in a room at a Commission on Lawyers Assistance Program meeting, thinking, you know what, these statistics are dark, they are dire, and this is not sustainable in the long term. We need to do something to change, to improve the health and well-being of lawyers in the profession. And so we got together and we formed this National Task Force on Lawyer Well-being. And I can go to the next slide, whose mission was really to make a change, to get the ball rolling, to seek a movement, seeking to create a movement towards improving the health and well-being of the legal profession. Not just lawyers, but law students and judges as well. Next slide. And so what we did, for those of you who draft by committee, I am here to say it can be done. There can be a short turnaround time. We started with this work in October of 2016. We had the report ready to go in June of 2017. It was the Path to Wellbeing, Practical Recommendations for a Positive Change. And the next slide, please. And in the report, what we did was we had various stakeholders. We identified what our challenges were and what our potential is. You know, we looked at all the data. We looked at from both the law school as well as the lawyer surveys, and we looked at our potential. What do we want to be, and how do we want to be it? And so in this report, and we can go to the next slide, we focused on impairment and well-being. And we came up with 44 recommendations that were directed at changing the culture of the legal profession, and we addressed them to various stakeholders. Judges, regulators, disciplinary boards around the country, law school, bar associations, like myself, the professional liability, the malpractice carriers, lawyers assistance programs, and had narrowly tailored recommendations that each of these organizations could put into place to continue this movement, to improve the health and well-being. Next slide. We also wanted to come up with a definition of well-being. We didn't want it to be, always being happy, and we certainly didn't want it to be, just the absence of illness. So we came up with sort of 6 groupings and what we like to call a strive to thrive, where a continuous process in which lawyers strive for thriving in each of the dimensions of their lives, whether it be occupational, being a lifelong learner, intellectual, spiritual, and that's not just, doesn't have to just mean religious, but developing a sense of meaning and purpose in your life, emotional, social, as well as physical. Next slide. We also wanted to come up with a construct of why we are doing this. What are the 3 primary reasons why something needs to change? And I like to start at the bottom because I think it's the most important and work my way, to the top. Humanitarian reasons. It's just a human thing to do, right? We can save lives by focusing on being healthy and well in the profession. It's good for lawyers, it's good for their families, and it's good for all of us. We thought, well, okay, if lawyers aren't going to buy or the stakeholders aren't going to buy what's good for, being a human being, how about rules? Lawyers always want rules, policies, procedures. We're rule abiders. So let's look at the rules of professional conduct. And Melissa's going to talk more about that. We'll hedge it in there. It's good competence, good to comply. And if you don't buy that excuse, let's go back to it makes financial sense. Organizational effectiveness. It's just good for business when you're talking about turnover, absenteeism, presenteeism, the cost of problematic alcohol use to businesses. It just makes financial sense to organizations where they can save money by focusing proactively on these issues. Next slide. You can see some of the costs associated with problematic drinking and depression. And I have, all of these have footnotes, and I have the actual sites or studies or data sources where we've gotten these statistics from. And you can see, total economic burden of alcohol use, over $250 billion per year. How depression affects days off, presenteeism, not being productive at work. Costs associated with turnover and burnout. Focusing proactively on these issues makes financial sense. Next slide. As I said earlier, focusing on Rule 1.1, the competence rule, providing competent representation to a client. Part of that means being a healthy lawyer at your core. Some states, and I can go on to the next slide, have actually adopted some of the recommendations in the task force report, where they have changed their black letter law to the rule, or they have added comments about mental, emotional, and physical ability in the comments to the rule. So attorneys know that it is important to be healthy and well to provide competent services to the clients. Next slide. I wanted to share with you some recommendations from the task force report around alcohol. And a lot of people have said, oh, this is a teetotaler movement. You're trying to get people to stop drinking at any social events or any work events. And I like to say, absolutely not. This is not that kind of thing. It is all about just a de-emphasis on alcohol at social functions, having a mocktail instead, having some other option, using tickets as opposed to having open bars, just not having the focus be on the drinks, having it be on an activity, on the social interaction, not the imbibing. I also like to think of it as from a diversity and inclusion perspective, where, you know, some people can't drink because they're alcoholics, but also some people don't drink for religious reasons, for personal health reasons. And so by having the focus be totally alcohol centric, are you not, you know, you're not including those people who feel uncomfortable for different reasons. So I just like to throw that out there as another reason why you want to think about de-emphasizing alcohol consumption at your event. Next slide.
And Tracy, just for a second, this actually came up at a CLE that was held at the University of Illinois at the end of February. I think it was either end of February, beginning of March. And actually, Dr. Uchiyama was present there as well as a speaker, but how participation in events, after work events that involve alcohol, sometimes people with families or single parents who were attorneys also felt left out of being able to participate and kind of climb the partner ladder.
Absolutely, and I think that's, you know, that's a concern. Certainly, peer pressure and you know, the need to be seen and be seen with, you know, a glass of wine or a cocktail in your hand. You know, and I think one of the ways that we get around this is certainly you can participate, and that's why we always, you know, this mocktail suggestion is a great idea, because you can still engage, you can still be at the work function, you can still participate in whatever activity is also going on, but the pressure to actually have an alcoholic beverage is not there. Some of the things that we see from my world, from a claims perspective and legal malpractice perspective, and as you can see, this is from the last study that the ABA does on malpractice claims, sort of anonymized from around the country. Another one's going to be coming out this year. 40 to 70% of all, and that's sort of a wide range, we'd like to get a better handle on that, which leads me to my next recommendation. 40% to 70% of discipline and malpractice claims actually involve some sort of substance use or mental health concerns. And as you can see up there from some of the indications where the claims came, it goes to, you know, the diligence, the neglect, the communication, those issues, which are also oftentimes triggered or impaired by problematic alcohol use or other mental health concerns, a direct causation or a direct tie. Next slide. I also like to show some of the recommendations for malpractice carriers, because as we said, data really informs. Data really is what pushed this movement forward. And so from a malpractice standpoint, getting data from claims and then using that data to incentivize insureds, you know, giving premium credits for having certain alcohol policies, return to work policies, leaving work policies in place, and knowing what sort of initiatives law firms have to incentivize well-being or focusing on getting treatment for mental health issues. Next slide. I spoke a little bit about the National Task Force, and I have the front page of the website there. It is people from all around the country getting together, and as particularly task force or committees in each state through the bar associations, through the lawyers assistance programs, through whatever organization. And I'll go to the next page there. You can actually go and see, and it's an interactive map of the United States where you can click on your state and see what your state is doing around well-being issues. And I've got Illinois up there as well, and I'm sure Diana will talk a little bit more about that as well. Things that different communities are focusing on in their state and local areas, different bar associations all around Illinois, having different topics, different education, different outreach to help the legal community along substance abuse, alcohol use lines. I think I have one more. Another thing that is happening in the community as well as in Illinois, not only the law schools, but a lot of Illinois law firms as well as legal employers have signed on to be ABA Wellbeing Pledge members. And this is really a pledge that law firms, legal employers are taking to improve the well-being of their attorneys as well as their staff in their various organizations. You can see what the challenge, what the mission is. And I think the next slide actually has ways in which you can take this pledge and implement various of these activities in your firm. Education, reducing the expectation of alcohol at events, partnering with labs and outside providers, something about, you know, the firm's core values, that we are really committed to a understanding and promotion of well-being, and that this is what we support, and from a leadership to top down. Next slide. We wanted to make it easy for people as well. You know, we didn't want people to have to recreate the wheel when they're looking for well-being concepts, topics, CLEs, programs, resources. And so one of the things that the group produced was the well-being toolkit. And in it, it has all sorts of guidance about how you can get this started in your workplace, in your work setting. You know, different factors, dimensions of well-being, as well as something as simple as, and really truly, you know, insert tab A into slot B, how to get a well-being program initiated and started in your workplace.
Okay. Now,
the next one's the last slide.
Oh, okay. Oh, that's what I was going to bring up.
Yeah. The last thing that I wanted to bring everybody's attention to is something that it's a national, you know, sort of initiative, but it's really taking root and taking hold in local communities. And it's Lawyer Wellbeing Week, which is May 4th through the 8th. Every day there is a different focus, and you can see what it is up there on the slide, where different organizations, be it law schools, employers, court programs, are putting on different activities, you know, CLEs, webinars, whatever the case may be, on one of these 4 areas. And information on how you can get more involved or how you can plan one of these activities, or even be one of the well-being champions that is focused on the National Task Force website, is available at the lawyerwellbeing.net website. And with that, I think the overview is complete, and I'm going to leave it to Diana and Melissa to get into the nitty-gritty of here in Illinois, as well as with the LAP programs and with the ARDC.
Okay. So next we have Melissa Smart. Melissa's with the ARDC, and she's going to cover kind of the do's and don'ts, and just being proactive, and I'll let you take it from there, Melissa.
All right, thank you. Can everyone hear me? I'm hoping volume's okay. Good deal. All right, thanks. I want to thank you very much for including us in this presentation, and it's really my honor and privilege to participate, especially with Tracy and Diana. I think it's important to point out, building on Tracy's very well-being report, that when those individuals responsible for that very well-drafted report and the recommendations that flowed from it, what they recognized was that they had to bring those stakeholders in. And you heard Tracy talk a little bit about the separate recommendations and individual recommendations that were directed to individual stakeholders. And I think what's fabulous about this particular presentation is that, you know, Diana and I and Tracy all represent 3 diverse elements, 3 different stakeholders, but how the 3 organizations can work together, or the 3 separate types of stakeholders can work together to continue to educate and reinforce a lot of the recommendations and wellness initiatives that were pointed out in broadcast as a result of the report. A lot of the statistics Tracy went through are well known. I just really value that they were able to put it together and make these recommendations. So that being said, Obviously, as the prosecutorial arm of the Illinois Supreme Court, I represent the one stakeholder on the regulatory end of things and addressing why lawyers need to be well, while Tracy took you through 3 different reasons why lawyers needed to be well. I'm going to kind of hone in a bit, if you don't mind, on the ethical implications and the regulatory rule following aspect of things. And by virtue of that, that means, I don't mean to disrespect or prioritize that over the other very important reasons why attorneys need to be well, i.e. the humanitarian reasons, the business related reasons. I mean, those are always very important, but the ethical implications and the rule violations are obviously near and dear to us at the ARDC. So I'm going to take you through a little bit of that. If you don't mind taking us to the next slide a couple quickly. And Michelle, I'm going to give you a warning that I am a fan of PowerPoint transition. So a lot of slides have a couple different transitions throughout. So based on our statistics alone, it really doesn't give you a good flavor for what we're dealing with at the ARDC as it relates to substance abuse issues and this, overarching issue of why lawyers need to be well. So just looking at the numbers themselves aren't really going to tell us much as far as how we deal with and what we're dealing with as far as substance abuse issues. Next slide. So what we did, and this was part of an initiative, if you could go to the next slide, starting probably in around 2010, 2011, 2012, where we began to keep statistics specifically on lawyers who identified as suffering from an impairment. And what we determined was that it was at least 25 to 30% of Illinois lawyers that were facing formal disciplinary charges identified as suffering from addiction or mental illness. The important aspect of that percentage or that statistic beyond that it reveals is that this is just the attorneys who identified as suffering from addiction or mental illness. As Tracy could attest to and Diana as well, prosecutors are prosecutors. We're not treaters. We're not psychiatrists and psychologists. So while we may suspect that an attorney who is dealing with an ethical issue or has a pending investigation at the ARDC is suffering from some addiction issue or mental illness issue, we cannot diagnose them so that it provides us with difficult hurdles from an investigatory perspective when we suspect someone suffering, but they're not identifying it themselves. And we've got some workarounds for those instances, but the fact that 25 to 30% of lawyers who are facing disciplinary charges self-identified as suffering from addiction or mental illness is pretty startling because we suspect that number is quite higher when you factor in the number that are suffering that do not identify. And by self-identify, that means that they've been diagnosed by someone. That doesn't necessarily mean they themselves determined it, but that they fronted to us as part of the disciplinary charges. I am, suffering from alcoholism, or I'm in the middle of, being treated, or I'm seeing LAP for depression issues or things like that. If the person identifies early on as suffering from some of those issues, we can automatically put them on a different track that doesn't necessarily lead to full-on discipline. And I'll talk about some of the nuances in a second. If you could move on to the next slide. Identified substance use or mental impairment issues of the attorneys that we saw had at least one, if not more, substance abuse. And when you look at the statistics just from 2018 alone, that number is 26%. What you need to kind of compare and contrast with is the number of our proceedings that are concluded by default. Now, that 13% number has nothing to do with substance abuse. That's merely the number of disciplinary cases that we brought formal disciplinary charges against an attorney and they did not show up at all to their own disciplinary hearing. As a result, in most default proceedings, if it's not disbarment, whatever suspension you receive, you will also receive a UFO tacked on, meaning your suspension will continue until further order of the court by virtue of the fact that you did not participate in your own disciplinary proceeding. So this is an extraordinarily egregious measure and step that is taken And it's taken not lightly at all, but it's because part of our initial of their own disciplinary hearing is a natural precursor that that we ask the court to tack on the UFO portion of the suspension. Why this factors into discussions of lawyer impairment is because obviously if someone is dealing with an impairment, particularly those that have not identified themselves as suffering from an impairment, they're more likely to kind of bury their heads in the sand and not show up, resulting in a very severe penalty that affects their license to practice law long term. This next chart here is of the 20 lawyers who identified as suffering from an impairment, what impairment it was that they suffered from, whether it was mental illness or substance abuse, the practice setting of those individuals. And as you can see, there's a staggeringly large number that are from the solo firm arenas. And then that they have identified as having more than one impairment, which is disturbing. Next slide, if you will. And then the next slide is just another graphic that I think Tracy may have used as well from the wellness study that talked about some of the specific struggles that attorneys face. I think the next biggest, and this is just conjecture on my part, the next biggest hurdle for us is going to be to deal with the anxiety issues, because they probably, and Diana can speak to this probably more than I, they go on and underdiagnosed, those who suffer from anxiety. And it's my, again, personal, unprofessional opinion that a lot of the substance abuse issues are derived from prevalence or utilization of other substances is a mask for the underlying anxiety issues. So that's something that I think is on the forefront of where we're at with dealing with and tackling these things. Next slide. And this is just a regurgitation of some of the things that Tracy had already mentioned as to why, as bar regulators, we need to be mindful of the struggles of practitioners and the rules therein. Tracy already identified a couple of rules, probably the most important, that are things that attorneys must realize when it comes to those who are suffering from impairment issues. Rule 1.1, obviously competence. If you're unable to practice law because of an impairment issue, you're going to have issues with 1.1. 1.3, diligence, attorneys who are neglecting cases because they're suffering from some impairment. And then 4.1 through 4.4, transactions with persons other than clients is something that you have to be mindful. Personal responsibilities, because oftentimes is the case, if you're dealing with an impairment issue personally, you're not necessarily on the ball as far as what's, most disconcerting as far as the rules. So the ARDC, in conjunction with other Supreme Court agencies, i.e. the Commission on Professionalism and Lawyers Assistance Program, has developed new rules and initiatives to help us wade through the dilemma of how do we investigate and deal with an attorney who is suffering from an impairment, and deal with it appropriately so that we keep in mind our mission to protect the public while simultaneously having these humanitarian concerns of this is a human being and they need to address their issue, and we need to help them come to Jesus as far as dealing with their issue. So the court has given us several new rules and new initiatives, but we can't forget about the old ones as we wade into some of the specific examples. If you could forward to the next slide. Mental impairment in and of itself is not an excuse for a rule violation. Attorneys have to be mindful of their obligations regardless, but you have to take into consideration as well that, beyond just competence, and other issues like that, you have to be mindful of your obligations to self-report certain violations and your obligations to obtain treatment if your firm requires it. And that's the first rule, that beyond just competence and the identified rules at the beginning, the firm's responsibilities when dealing with or organization that is suffering from impairment is a major issue. And that's Rule 5.1. I think we missed that slide, but it's in the presentation itself. So hopefully the materials will be distributed. But Rule 5.1 is an obligation of, the overarching entity, whether it be a firm or governmental entity. And when you're dealing with an attorney who is suffering from impairment, a firm has obligations to either report that impairment and to take certain steps in order to make sure that they are not sending out an attorney into the world practicing that may have been suffering from impairment issues. And then, of course, the next slide discusses, the overarching attorney misconduct rules that kind of flow from potential untreated impairment issues, and those are issues related to convictions of crimes for crimes and other misconduct. So, it's an unfortunate flow from some untreated impairment issues that they don't come to our attention until the attorney has been caught up in some ancillary criminal matter. Usually that takes precedence of it is secondary, but keep in mind, if you are convicted of a crime, even if it's a DUI, that you have an obligation to report that conviction to the ARDC pursuant to Supreme Court 761, because pursuant to Rule 8.4, criminal conduct that reflects adversely on the profession of law is in of itself a rule violation. Self-reporting with an impairment issue does not necessarily mean you are going to have a formal disciplinary case filed against you, but in most circumstances, it helps us understand which attorneys are dealing with problems and how we can exact remedial measures in order to prevent those from being bigger issues. And I have, in the next few slides, some kind of cautionary tales. If you could forward over to the next one. But, before we go into just a few of the many cautionary tales that we have formally at the ARDC dealt with where attorneys are suffering from impairment issues, I want to make sure that everyone understands that, we do, by virtue of explaining and discussing some of these precedent cases at the ARDC, they're not meant to embarrass any of the individual respondents. This is meant primarily as a cautionary tale. And it's a sad reminder of the consequences sometimes of untreated issues. And, we're not, I want to make sure that we're not embarrassing anyone, but it's important for practitioners to learn from the mistakes of others. And unfortunately, these are some of the cases that led to formal discipline. We seem to have skipped over again the first slide, which it's actually the first slides, 48 and 49, Michelle. And I don't like to discuss this case because I was personally handled the original disciplinary matter, but you can't help but bring it up. Actually, one more bit. Yeah, there we go. And again, I apologize. The transitions don't seem to be going through as far as the PowerPoint's concerned. But we did just have a pretty horrific anniversary, and you may have read about it in the papers, that the little boy that was lost in McHenry County about a year ago, or was reported missing, I should say, happened to be the son of an Illinois attorney. And unfortunately, that Illinois of this, most recent issue had come to pass. And what happened in the disciplinary case was, this was several years ago, we received a report from a McHenry County judge that an attorney was assisting his client, a female client, in selling property from the female client's home when the attorney was representing the female client in a divorce proceeding, and there had been several court orders issued that the female client could not take any of the marital property out of the home. It was disconcerting to the judge that the attorney appeared to be having a sexual relationship with the client, but that the only definite misconduct that he could report to us in order for us to investigate was that they were operating in conjunction with one another to sell marital property in an effort to get their hands on as much cash as possible, acting in direct contravention to the judge's orders. So we began an investigation. During the course of our investigation, the attorney was arrested, and we received subsequent reports from the Henry County Sheriff's Office that he and his client were living together, that they were selling literally everything that wasn't nailed down in the former marital residence in order to gain as much cash as possible. And then they were both arrested for shoplifting. And at the time of the arrest, they both had track marks up and down their arms, and the female was visibly pregnant. We determined that we were going to attempt to take quick action in the case because, once again, these are the signs of an attorney who's suffering from some kind of an addiction. There's not any set script to follow in these types of situations other than, we suspect drug use is fueling some very poor decisions by this attorney. But again, you can lead a horse to water, you can't make them drink. Mr. Freund was in a bit of denial as it related to his substance abuse issues. We ultimately had him evaluated, and our appointed evaluator, in his professional opinion, came back stating that it was one of the worst heroin addictions that he had ever seen across the board, much less from an attorney. We were able to get Mr. Freund to agree to a discipline that effectively dealt with the misconduct, which is violating court orders in representing his client, which would not necessarily result in a very significant sanction, meaning time served. All suspensions and discipline from the ARDC are significant, but I mean from a time served perspective, conditionary probation in order to help him address his substance abuse issues. Within months of that discipline becoming formal, if you could go to the next slide and even the one after that, unfortunately, Mr. Freund dropped off our radar because he stopped complying with the conditions of probation when we went in on a rule of show cause to effectively stop him from practicing law while, even though he had been forced to undergo drug treatment, because he no longer cared to participate, we would have to take away his license to practice law was really the only consequence that we could met out. So he was effectively disbarred at the time that the little boy went missing. And some of you who deal with these types of issues in a daily basis can understand this feeling when they reported that the little boy had gone missing. When my heart sank, having dealt with Mr. Freund from a disciplinary perspective years earlier, when my first initial reaction was that they had probably harmed the boy and that the boy was probably dead instead of being just missing, which turned out to be the unfortunate conclusion of that case. And both the attorney, Mr. Freund, and his now wife, I believe, the boy's mother, are both incarcerated. I think the mother has pled guilty to the murder while the father's awaiting sentencing. Again, a cautionary tale of untreated drug abuse where the ARDC did as much as we possibly could to attempt to hang this attorney's law license almost over his head effectively in order to encourage him to seek treatment. But his addiction, unfortunately, was so bad that that was not enough, and he lost his law license as a result. But that's really all that we could do. Melissa,
in the interest of time, what I'm going to do is skip ahead to Diana, so she can cover the lawyer's assistance program, and so that attorneys that find themselves in areas where they impaired will know where to go for those resources.
Perfect. Thank you.
And especially in light of COVID-19, where some of these stressors are occurring more than normal, and now I'm having technical difficulty. Okay, I think it's scrolling ahead, so moving just a little bit slower. But Diana, if you don't mind, while I'm skipping ahead to yours, just chiming in regarding the lawyer's assistance program. Do I have you? Okay. Okay. I don't hear anything. Is it I know on my end my slides, the slides aren't advancing. Okay. Okay. Hmm. Diana, uh, can you hear? Okay.
Can you hear me?
Oh, yes, yes, I can hear you now.
Okay, I don't know what happened. We were talking before, so I'm not sure what happened. Okay, so I'll just start off by, you heard nothing from what I was saying. So the Lawyers Assistance Program is a confidential resource for lawyers, judges, and law students. And basically, it's under Supreme Court Rule 1.6. It's confidential with immunity, which means we're like the Las Vegas of law. So a lot of people who won't seek services in other traditional forms like EAP and HR resources often will reach out to the LAP so that we can provide help to them. One of the things you should know is that we provide free assessments and evaluation. We do free therapy. We have support groups, a men's group, a women's group, a young lawyers group, and we also provide we have 2 AA meetings a week that we do now virtually. Obviously, you know, our main office is at 20 South Clark downtown, but we're doing everything via telehealth now, and it allows people to access services very easily, and we're able to evaluate people all throughout the state of Illinois. I think that what's interesting is, part of your ARDC dues goes to support LAP. Now, clearly, it's not enough because I have to do a lot of fundraising in an effort to support lawyers who don't have health insurance, mainly solo practitioners or small practice firms. But we never turn anyone away because we believe that everyone should have free access to services. And so we encourage people who are suffering to reach out for help. One of these things is to see the face of LAP. So I do a lot of CLEs, and the goal is to make people less afraid to access services. Tracy talked about the stigma associated with, reaching out for help, which is a barrier for many people. But I can tell you, like this morning, I received a phone call where someone had seen me at a webinar 2 or 3 months ago, had identified significant symptoms of mental health, depression, and anxiety that I had spoken about, and then finally outreached for services given the current state of the pandemic and his increasing anxiety disorders that were taking place. Now, I think Tracy and Melissa spoke about the rate of mental health and substance use issues in the field of law. So, after the survey was completed and released in 2016, 28% of attorneys identified as having significant depressive symptoms. 19%, as Tracy had said, had anxiety disorders. 23% were under chronic stress, and about 21 to 28% had substance use disorders. But I think you saw with Melissa that those numbers are exceedingly low. Obviously, it's a self-report study, so in any self-report study, people minimize their state of distress, and again, that fear of being outed as a person who has problems in a profession where you are a problem solver always reduces the number of people who will self-identify. One of the things you should know is that I think the rate is exceedingly high. There have been studies outside of the well-being studies where a lot of attorneys suffer from social anxieties, as described in a slide by Melissa from the ARDC. What happens is people are required to perform socially as attorneys, whether they go to court. And so a lot of people, I tell people all the time, we all have numbing mechanisms when we're dealing with overwhelming stress, anxiety. Some people, it's alcohol. An overwhelming percent of people use alcohol in the field of law. There is some studies that show our type A personalities, the adversarial nature of law, and just kind of the overwhelming pressures that we face as perfectionists create this template where alcohol is kind of what we gravitate to. But there is also a culture associated with law, which we've talked about, in that my son is in the military, and I had done a podcast and sent it to him, and he said, wow, it's so similar to the military, these high-functioning individuals who use alcohol as their coping mechanism, and it's so normalized within the profession. And I said, it's absolutely true. So the field of law has a culture that kind of cultivates and encourages substance use problems. The problem is that not everyone uses alcohol as their drug of choice, that many people utilize other sources such as, drugs. And I think Tracy and Melissa both had slides, opioids and prescription meds, benzodiazepines, that's a drug of choice for lawyers because it's a numbing device used to treat anxiety. It's not actually a treatment, it's actually just numbs you, like alcohol has one of the highest rates of addiction. Attorneys who have anxiety and panic attacks take sleeping medications, but over time, a sleeping med is only supposed to use in the short term, and it can increase sleeping problems and increase anxiety. Also, attorneys abuse marijuana at high rates, and what we see is that, with the legalization of marijuana, it's created kind of within the pandemic, another pandemic of substance use problems. It can increase anxiety. The THC content in marijuana currently is up to 28%, and in the edibles up to 80%. And in the old days, in the 60s and 70s, it was 3 to 4% THC. So we're seeing people who are having more significant issues. And, all my slides, I'm just going to brief, we don't have a lot of time, but long-term mental health and substance use issues that go untreated can lead to cognitive issues, right? The bad news is we're all in a state of decline because we're over the age of 25. but over 60, substance use and mental health issues and aging can increase cognitive issues. And the problem is, as lawyers, we need our cognitive functioning to be optimal. So we see high levels of catastrophic events leading to ARDC disciplinary actions. So I know we're out of time. I didn't have a lot of time to speak. I want you to know that the pandemic has also, due to the uncertainty and ambiguity of this current time period, our health and safety are at risk, as well as our financial security, leading to catastrophic levels of anxiety and depression, just because our basic needs are really not, they're at risk right now. And so we are seeing people who are outreaching to us in catastrophic numbers with catastrophic issues. And I use that word lightly, unfortunately, but I have to use that word because some of the suffering we're seeing is at a rate we've never seen before, which makes sense given the unstable nature of external setting that we're all facing. We've been forced into environments at home. So what I would tell you is to reach out to LAP. I don't have a lot of time to go over things. I have a LinkedIn page where I post a lot of articles and make a lot of comments about articles. But right now, it's really important to surround yourself with as much structure and support as possible. Telehealth measures, you know, substance use. The rate of relapse we're seeing is pretty unfortunate right now because a lot of the structure is gone. I tell people addiction waits for times like this, right? When people are isolated, don't have as much support. But the answer to addiction is connection. And so if you yourself are suffering from a substance use problem or you yourself are struggling with a mental health issue, then LAP is here to help you. And I encourage you, my cell phone is 630-642-9089. I'd encourage you to reach out for help. We have a Get Helpline. We have a website. But these numbers that we're seeing that Tracy and Melissa both spoke to, people lose everything before they're willing to access help. And we want to access people before they lose everything.
Okay.
So,
Okay.
Michelle, thank you.
Thank you. Thank you. And what I'll do is I'll make sure that the slides are available to everyone that participated. And again, thank you to all of the panelists. Lots of good information, resources as well, and for the participants as well. So please share what you've learned, the resources that you've learned about, the statistics that you've learned about, and we'll get through this.
Thank you.
Thank you. Thanks for letting me participate.
Yep, thank you.
Thank you. And I put everyone else on mute, so I understand if you're saying thank you and I can't hear you. So, because someone was typing. No, just joking. Okay.
Michelle, do you want us to stay on in case there's questions?
Yeah, let's do that. Let me see. And then if there aren't any after about 5 minutes, then we can go. Because for some reason I'm still trying to share your slides. I opened and closed, but that didn't work. But I'll have.
I don't know if there's like a time delay because I can't see anything either. But I know, I can talk on and on. So.
Okay. see. Oh, and this is to answer Dominique's question regarding MCLE. If you registered for this WebEx and I have your ARDC number and your email address, then you'll receive it via email. Yes, yes. They will be emailed as well. It is a large file, so I'll also, if it's too large to email, then I'll have it on the Liquor Control Commission's website under education, and or I'll provide the link to that, and then you can download it from there. But as long as I have your ARDC number and your email address, then I can email the CLE certificate. Okay. So it's about 1:06, and again, thank you again to the panelists. Thank you for the participants joining in. And just email me if you have any questions, or if, let's say within a week, if you haven't received your certificate. And my email address is Michelle, MICHELLE.flag@illinois.gov. And I'll put it in the chat box as well. Yeah. Okay, so I'll end the presentation now.